Hi, my name is David P. Shapiro. I'm the owner and managing partner of the law office of David P. Shapiro, located in San Diego, California, where my firm helps good people regain control of their future when charged with a crime. And this video, I want to talk to you about AB 1950. And we've done some videos in the past that you can find on our YouTube channel, myself, Stefano Molea, Keegan, the other attorneys at the firm, about AB 1950. AB 1950 came into effect, passed into law, January 1st of 2021. And what AB 1950 did was change the maximum length of probation you could be on for certain offenses. For many misdemeanors, it dropped the ceiling from 3 years maximum of probation to 1 year. For many felonies, it dropped the maximum of probation from 3 years to 2 years. And that's really important, okay? Because what probation means is if you are convicted of a crime and you don't go to prison. So probation can mean you get jail up to a year. Probation can mean you get no jail. Probation can be you get somewhere in between. But what has been going on is we've seen people so often be sentenced to 3 years probation. Well, why? Well, that's what we do, in San Diego, or that's what we do in California. You're convicted of a felony, you get 3 years probation. Maybe you terminate it early, maybe you don't, and you're supervised for 3 years. But in reality, you've probably only really been supervised for the first year. And then next thing you know, you're just phoning in. And then next thing you know, you're really not getting supervised at all. So California looked at it and said, okay, well, it really doesn't make a whole lot of sense. It's not great use of resources. And the best part of being on probation to rehabilitate and to help with services that probation and the county can provide for those who need it are really within the first 12 to 18 months on felony probation. So a lot of felonies reduced to 2 years, certain exceptions, sex offenses, domestic violence offenses, most if not all serious or violent strike offenses as well. One thing though in particular that even we as attorneys and myself and Stefano Molea and Keegan and my firm, we are very much on top of the law, very much on top of continuing our education to make sure we're serving our clients better. And something that really surprised us was AB 1950's effect on a wet reckless conviction. Wet reckless convictions, sometimes you see people charged with the DUI and they resolve it for reckless driving after consuming alcohol, or reckless driving after consuming alcohol or drugs, or just drugs. And, historically, there's really been four main differences between a wet reckless and a DUI. Well, the first was the maximum you could get on a wet reckless is 90 days in jail. The maximum you could get on a first-time DUI is 180 days jail. So in many ways, it's less serious of a misdemeanor as far as what the worst case you could get. Another difference between a wet reckless and a DUI historically has always been that if you're convicted of a wet reckless, even though it's still 2 points on your license the same way a DUI would be, it would not automatically trigger another DMV suspension because you're convicted of a wet reckless in court. You get convicted of a DUI in court, DMV gets notified, your license usually gets suspended again. Another difference is the fine. Usually a fine in San Diego on a first-time DUI is a little bit over $2,000. Fine on a wet reckless a little bit over $1,000. And the fourth main difference historically has been the term of probation. Wet reckless probation would usually be 3 years. DUI would be 3, 4, or 5 years. Now, under AB 1950, something like I said that even surprised us was that a wet reckless probation is 1 year. So you can't be on wet reckless probation if you get convicted in 2021 or beyond, and arguably even if you were convicted previously for more than 1 year. And that really is a big difference between a DUI and a wet reckless. And it's going to be interesting to see how prosecutors handle that moving forward, if they're going to be more reluctant to offer wet recklesses than they might have in the past, and what effect maybe COVID might have on that. And are we going to have situations where it's going to be DUI or nothing more than ever, because prosecutors are going to want you to be on probation for more than a year, and you just can't do that anymore with a wet reckless. So something that's really important, sort of like a hidden gem in AB 1950, at least as the law stands now being February of 2021, is that a wet reckless under AB 1950, maximum 1 year probation. Keep that in mind if you're charged with a DUI. That has increased the value of a wet reckless plea if that's in your best interest. It's differentiated a wet reckless from a DUI even more. It's something you should be aware of, and most importantly, it's something your attorney should be aware of when negotiating, when evaluating your case in the days and weeks and months ahead. So if you have any questions about AB 1950 in general, specifically as it relates to the term of probation for the offense you may have been convicted of, or the offense you may have been charged with, or the offense you really want to resolve your case for, feel free to reach out to my firm, 619-295-3555.